We begin this morning with our breaking news. Former President Donald Trump is safe, and a 20-year-old shooter is dead after a shocking assassination attempt on the former president in Pennsylvania yesterday.
And welcome to Hannity, and this is a Fox News alert. Today, the former president of the United States, Donald J. Trump, was the target of an apparent assassination attempt. One innocent attendee is now dead. President Trump, we are told, is alive and well and now in a safe location.
It's 13 July 2024, and 20-year-old Thomas Crooks climbs on top of the roof in Butler, Pennsylvania, armed with an AR-15 rifle. His mission is to shoot former U.S. President Donald Trump, the current Republican Party presidential candidate, at a political rally. In a few days' time, Donald Trump will be the Republican Party's official presidential nominee, so time is of the essence for him. Just minutes into his speech, shots were fired at the candidate.
And you know, that's a little bit old, that chart. That chart's a couple of months old, and if you want to really see something that's said, take a look at what happened.
In this video, we will discuss the potential criminal charges that Thomas Crooks could have faced had he lived to see a trial. Hello everyone, and welcome to Legal Counsel TV, a channel dedicated to discussing the various legal topics of the day. Thomas Crooks is armed with an AR-15 semi-automatic rifle. During the shootout, Crooks shoots and kills 50-year-old retired firefighter Corey Compatori. He wounds 2 other people and also strikes Donald Trump in the upper part of his ear. Trump will later say that turning his head at that very moment saved his life, as the bullet narrowly misses his head. It's alleged that Crooks fired 8 shots from about a distance of 150 yards. At first, Crooks fires 3 shots. Trump ducks and seeks refuge behind the podium. Panic ensues in the crowd, and within 3 to 4 seconds after the first few shots, the gunman fires another 5 bullets. By this time, some Secret Service agents have come to Donald Trump's aid, and they shield him with their bodies. About 75 seconds since ducking to the ground, Trump raises his fist and mouths the words, "Fight, fight, fight." The crowd chants in support of their candidate. The iconic videos and photos travel around the world, and they will surely go down in history. Unanswered questions remain, such as what were Crooks's motives? Did he really and truly act alone? Why was he permitted to enter the vicinity of a political rally with a rangefinder? Why didn't law enforcement take him out earlier? The roof that he lay upon was unmanned by law enforcement. Why is that? In addition to these questions, there are also legal questions that arise, such as, in the event that Thomas Crooks had survived, what crimes could he have been charged with? Do his parents face criminal liability, or are they culpable in any other way? Is there any branch of government liable for a lapse in securing a presidential candidate? We'll take each of these questions one at a time. First of all, what crimes could Thomas Crooks have been charged with if he had survived? In the event that Crooks had survived his attempted assassination of Donald Trump, he would have at the very least been charged with murder and attempted murder in the first degree. We can safely surmise that Crooks intended to kill Donald Trump. If he had managed to kill Trump, he would have been charged with first-degree murder. An intentional killing amounts to first-degree criminal homicide in Pennsylvania. During the course of his attempted murder in the first degree, he ended up killing a bystander. Corey Compatori, a retired firefighter, died the moment he dove to shield his family from incoming bullets. Attempts to save his life were futile. Had Thomas Crooks lived, he would have been liable for murder in the second degree. In the course of committing the felony of attempted murder in the first degree, he wound up killing a second person, which would have made him liable for murder in the second degree. Crooks could have also been charged with attempted first-degree murder of 3 people. 2 men were critically injured, and Donald Trump himself was struck in the ear during the fiery exchange. But given the high-profile nature of the events, the legal implications wouldn't have ended at state level. Certain VIP individuals are protected under U.S. law. The Presidential Assassination Statute, 18 U.S.C. 1751, makes it a federal offense for anyone to assault, kill, or kidnap, or attempt to conspire to kill or kidnap the President and Vice President of the United States. But at this stage in his career, Donald Trump is only the former president. Is there legislation designed to protect a man such as him? The answer is yes. Trump would have been covered by 18 U.S.C. 879, which prohibits knowing and willful threats to kill, kidnap, or inflict bodily harm against the following categories of people who are protected by the United States Secret Service: a former president or a member of the immediate family of the former president, a major candidate for president or vice president, or a member of the immediate family of such a candidate. The Justice Department says that the purpose of the statute is to prevent threats against former presidents and other Secret Service protectees who are not covered by the presidential threats legislation. Furthermore, it is reported that Crooks had a transmitter that was wired to an improvised device hidden in the boot of his car. This would have helped to extend the federal government jurisdiction in any pending trial had Crooks survived. The man who bombed the Boston Marathon was charged and convicted of using a weapon of mass destruction under 18 U.S.C. 2332. So it's likely that the federal prosecutors would have charged Crooks with a similar crime in the event that he had lived. Legal question number 2. What liability, if any, could his parents face? At this stage, we don't have any reporting on the relationship between Crooks and his parents. It has been said that his father was a Republican and his mother was likely a Libertarian or a Democrat. Crooks' father purchased the guns that were kept at their shared home. It's alleged that the AR-15 rifle that Crooks used on that fateful day was one of those guns, and that his father had purchased it. Someone had used the email address linked to the father to purchase the gun parts from eBay not long before the shooting. So did the parents know that their son was dangerous? Well, no one knows that for a fact at the moment. However, news reports say that after Crooks opened fire, his father called police to report that he was worried that his son and his AR-15 rifle were missing. Generally speaking, a person's family members are not responsible for the acts of that person. You may be thinking of the groundbreaking Michigan case where the parents of Ethan Crumley were both convicted of involuntary manslaughter when they failed to prevent their son from committing a school shooting in 2021. They were sentenced to at least 10 years in prison. The judge said that their convictions were not about poor parenting. On the contrary, their convictions confirm repeated acts or lack of acts that could have halted an oncoming runaway train, that is, the shooting that their disturbed son had committed. The Crumley case is distinct from the Crooks one in that there were all sorts of red flags surrounding Ethan Crumley's actions. On the day of the school shooting, the school authorities called Ethan's parents to discuss his violent drawings. Words such as, "My life is useless," "blood everywhere," and "the thoughts won't stop, help me," were so disturbing to his teachers that even they raised the alarm right away. And yet his parents claimed that they had no idea that their child, a minor of school-going age, was a potential danger. They purchased him a gun 4 days before the attack, despite their knowledge that their son Ethan had been hearing voices. The Crumleys were tried for involuntary manslaughter for both their acts and their failures to act. Now back in Pennsylvania, where the Crooks reside, the law is a little different. Pennsylvania law states that a person is guilty of involuntary manslaughter when, as a direct result of the doing of an unlawful act in a reckless or grossly negligent manner, or in doing a lawful act in a reckless or grossly negligent manner, he causes the death of another person. The Pennsylvania statute uses the word doing, and that term seems to require that the person should act rather than punishing them for a failure to act. Another important distinction to the Crumley case is that Crooks was a 20-year-old man. Yes, he lived at home with his parents, but the Crumley prosecution was rooted in the legal duties that a parent had towards their minor children. So the same principles of parental control of a minor child would not apply here. Legal question number 3. Could there be liability for the perceived security failures? Given his importance as a former president and the Republican candidate for president, Donald Trump is protected by the Secret Service. At a political rally and at venues such as these, Secret Service efforts are bolstered by local law enforcement, such as the Pennsylvania State Police and sheriff deputies. The full details of what unfolded that day are still being investigated, but what is clear is that the rooftop upon which Crooks lay and took aim at Donald Trump and other victims was unmanned. The Secret Service say that they had delegated the protection of the building to local police, but the police department say that the Secret Service had ultimate supervision and thus responsibility. The House Oversight and Accountability Panel have subpoenaed the Secret Service Director, Kimberly Cheatle, to appear before the committee for what is scheduled to be the first congressional hearing into the attempted assassination of former President Donald Trump. In the meantime, what we know is that after the shooting, the FBI took over the investigation from the local police. A spokesperson for the FBI says that they are investigating the shooting as a potential act of domestic terrorism. As of right now, the FBI believe that Crooks acted alone and that there are no current public safety concerns. What liability, if any, could law enforcement face for a lapse in the provision of security? For this answer, we could refer to the public duty doctrine. It is a legal principle that states that government officials, including police officers, absent a special relationship, do not have a specific duty of care to individual members of the public. Instead, they have a duty to protect the public as a whole. This doctrine has significant implications for police officers and their interactions with members of the public. Some scholars argue that the public duty doctrine cannot be justified because it protects the government from liability at the expense of justice for the individual citizens who have been harmed by governmental action or negligence. In this instance, Donald Trump could arguably be that citizen who would suffer from the injustice if a ruling was made against him in a hypothetical case. For more information on this doctrine, we refer you to the case of DeShaney versus Winnebago County Department of Social Services, a lawsuit filed by a concerned mother against the DSS in 1983. Please subscribe to our channel and comment below if you'd like us to do a follow-up video on this interesting topic. Thank you for watching.